करके
अभी नहीं
ओके तो अभी हाय एवरीबॉडी गुड मॉर्निंग
अभी नहीं
ओके तो अभी हाय एवरीबॉडी गुड मॉर्निंग we'll wait for another minute. We'll let some participants join and then we'll begin the session.
Meanwhile, learners, if you could quickly tell us where you're coming from, if you are a law student or a professional, you can just quickly introduce us on the chat box. So we will have an idea, sir will have an idea of what kind of audience is coming. So please feel free to, respond on the chat box and tell us your name, if you're a student, which year are you from? If you're a professional, what exactly do you do? So we would really appreciate that. Yes, I think I have enabled the chat. Now you will be able to respond on the chat box. So yes, please respond on the chat box, everyone. Please don't use the Q&A box. I request you to use the chat box to do this. Yes, I think now you will be able to definitely send the chat. The chat box was disabled, so now it has been enabled. Please start. Yes, finally.
Hi Krishna, good morning. Hello Pragadish.
Oh, so many of them now.
Oh, so many messages. So nice to see you. Khushi, Kevin, Nikita, Anand. Lovely to have you all. I officially welcome you all to the masterclass.
Okay, great. So we have a lot of students from third year, from final year. There's an advocate, Nishant is from final year.
PhD, one PhD student was
One
also.
of the PhD student as well. Amazing. I really like the mixture of this, the variety, the diversity that all of you are coming from. Okay, litigation.
Litigation from Bangalore. So nice.
Yes, very nice. Second year students. Okay, we have first year BA, BBA, LLB students as well. I want to specially congratulate the first year students because at this time you're taking so much interest and you're actually wanting to kickstart your career and learn so much. So congratulations to all the first years especially.
We also have somebody who's a master's in criminal and security law. So I think Madhur Ravali, she will or he will take something really interesting back from this session. We also have one principal of SP College of Law from Chandrapur, Maharashtra. Very nice to have you as ours.
Okay, great. Okay, great, Samiksha. I think now we can start. So over to you.
Hi, everybody. I officially welcome you all to the masterclass. It gives me distinct pleasure to welcome you all on this riveting session about terrorism laws and national security in India. So I thank you all for showing your interest and joining in. I also appreciate your interest and inclination towards a subject which is so prevalent and so threatening, yet without so much informative dialogue and discussion. In an era which is marked by so many unprecedented global challenges, understanding the intricacies and little counterterrorism measures and legal frameworks is so paramount for safeguarding our society and to uphold our own fundamental human rights. In the recent years, India, like many other nations, has been grappling with the multifaceted threat of terrorism. With the rise of extremist ideologies, transnational networks, and also evolving tactics of violence, they come together to pose a very complex challenge on the security and stability of our nation. But in response, India has also come to implement a range of legislative measures and security protocols, which aim at combating terrorism while upholding rule of law and protecting the civil liberties. Throughout our webinar today, we will be delving very deep into the intricate landscape of terrorism laws in India, wherein we go on to explore the historical context, the legal foundations, and the contemporary applications of the same. We will also examine the evolving nature of the terrorist threats, the role of the state and the non-state actors in the same, and the challenges which are posed by the terrorism and warfare. As we navigate through the session and the webinar today into this intricate terrain, I encourage you all to please engage in dialogue, to pose questions, and also feel free to share your insights so that it can enrich the quality of the conversations and bring a collective understanding of the pressing issues together. Now, this will also help us to foster a collaborative exchange of ideas and perspectives, and we can collectively strive towards a formulation of comprehensive strategies to ensure a great dialogue. Without much ado, I would also like to share a little in brief about the schedule of the webinar. From around 11:10 to 12:30, we'll be discussing about understanding of the terrorism and national security with reference to India. We'll also talk about the key legislative measures aimed at combating of terrorism. We'll also talk a bit about developing an insight on national security strategies, the role of the specialized agencies, and international cooperation along with balancing of securities and civil liberties. Post that, from 12:30 to 1 p.m., I would like you all to hold on, and I would all like to thank you all for joining in. And we will have a bonus registration opportunity for the LLS criminal drafting course. Along with the same, we'll also answer a lot of your questions. In my closing, I will like to extend my heartfelt gratitude to our esteemed panelist, the pioneer, retired Justice B.N. Sri Krishna, and I invite Akansha, the head of our Lawctopus Law School, to share a brief introduction about a man who actually needs no introduction.
Thank you so much, Samiksha, for that. It's definitely an honor and it's my pleasure to introduce retired Justice Sir B.N. Krishna, sir. Of course, as Samiksha rightly pointed out, he needs no introduction, but just for the benefit of all, I'll quickly brief you a little bit about him. This might take a while because I have picked up very few things that I could actually summarize. Otherwise, it would have taken me an hour to actually introduce sir. So B.N. Sri Krishna sir is an Indian jurist. He's a retired judge who served his tenure from 2002 to 2006 in the Supreme Court of India. Sir headed the Sri Krishna Committee from 1993 to 98, and this was about the investigations of the Bombay riots of 1992 to 1993. Post this, he headed the 6th Central Pay Commission in 2006, and he has also headed a one-man commission to inquire about the Madras High Court incidents of February 2009. In 2010, each year there was a recognition. So in 2010, a 5-member committee was constituted, and Sir was the chairman of the Sri Krishna Committee on Telangana. This committee was headed by Sir, and it included members from government, different variety of industries, lot of academicians. And this committee also had the mandate to propose a draft bill for data protection. In fact, currently, the data privacy laws, the drafting of the data privacy laws, Sir had a big role to play in this. And this data privacy law is going to regulate how these technological giants are going to, from US and elsewhere, are going to operate in the country. Sir was invited by United Nations High Commissioner for Refugees to Geneva for a seminar on new forms of persecution in 2000 and on justiciability of economic, social, and cultural rights to New Delhi in 2001. He's also on the editorial board of the Journal of the Indian Law Institute. He's a life member of National Institute of Personnel Management and is also associated with the Western Region Committee of the Employers Federation of India, Industrial Relations Research Association USA, and the International Bar Association UK. Currently, he's the chairman of the Financial Sector Legislative Reforms Commission, and he currently also works as an independent arbitrator for many matters. Sir, it's an honor, it's a privilege, and thank you so much for gracing us with your presence. It has definitely crowned this event. And I am personally looking forward to learning a lot from you. And I can't even imagine that how all the learners who have joined today, how excited and how curious they must be to learn from you. So thank you so much, sir. And over to you, Samiksha.
Thank you so much, Akansha. And sir, truly it's an honor, it's a privilege to actually hear from you, actually learn from you, and be able to attend this session. Without further ado, sir, I request you to please begin the session.
Just one last thing. Sorry to interrupt, sir, you and Samiksha. Learners, if you have any questions during the webinar, please post it on the Q&A box. Okay, sir will address it after he is done with his content. If sir asks you something and if you want to talk in general, then use the chat box. So please create this difference so that your questions are addressed properly, and we are able to address all your questions and all your queries as well. Okay, and I request all of you to stay till the end to take the best out of the bonus opportunity that we have for all of you. All right,
Yes.
so thank you so much, and over to you, sir.
We have very, very exciting bonuses, opportunities for you waiting at the end. So I hope you're all ready with your notebooks, pens, water bottles, and a lot of questions and enthusiasm. Thank you, sir. Over to you, sir.
Thank you. Thank you for that long and unnecessarily avoidable
Not at all, sir.
one little sentence saying that former judge of Supreme Court should sum up the whole thing. It's not necessary to talk about all this. Anyway, thank you very much. Terrorism and counter-terrorism measures has been a global issue. Every nation is sovereign. Sorry, my throat is really bad, so if I keep coughing in the meanwhile, you will pardon me. My apologies. Every nation is sovereign and is entitled to have its own laws. Nobody can tell, one state cannot be told by another state or another nation and say, you must have this kind of law and all. But two events changed this thinking. One was the First World War, which led to the League of Nations. The League of Nations was some kind of a loose organization where all the states who were affected by war and who were affected by the prospect of future war came together to devise some mechanism by which peace could be established. Then came the Second World War, which was even more devastating. And we all know what happened in the Second World War. So as a result of which, the United Nations came into existence. The United Nations is again a body of members where every member becomes, every entitled state becomes a member, and they enter into some kind of a compact that whatever you agree upon by collective passing of resolutions, we will implement. Now, this was the reason why each of the member states was told that counter-terrorism is one subject on which you should legislate domestically. Now, this is so far as counter-terrorism measures and why they affect the entire world. Now, I'll go into it a little later. Now, let's understand what is terrorism. I have a maid servant whose husband is a drunkard. He comes home and beats her and terrorizes her. Can I say that what he is doing is a terrorist act? So what is terrorism then? Terrorism is not simply frightening somebody. If you are walking on the street and somebody comes and frightens you, that is not terrorism. Terrorism is indulging in acts of violence or threats to intimidate or coerce a civilian population or a government. And the goal of terrorism is to further political objectives, social or ideological objectives. It can include the use of murder and bombing, random bombing to achieve political aims or to force governments to do something or the other or refrain from doing something. It is also defined as the unlawful use of violence or threats to intimidate or coerce a civilian population or government with the goal of furthering political, social, or ideological objectives. In its broadest sense, it is the use of intentional violence and fear to achieve political or ideological aims. Now, in India, The first time we came across, if you remember, was when there was terrorism indulged in Punjab. The Khalistan movement gave rise to terrorism. We'll go into that, how it evolved in India and what the law of today is. Now let's talk of the United Nations. I was telling you that the United Nations jointly decided that terrorism is a threat which needs to be attended to. Initially, it was a matter of just academic discussions and all that. But after the 9/11 in the United States, it became a burning issue and people had to sit down, take notice and act. So what was done? The United Nations passed a resolution, I think it is number 288, called the Global Counterterrorism Strategy. And that is a unique global instrument to enhance national, regional, and international efforts to counter terrorism all over the world. Through its adoption by a consensus in the year 2006, all United Nations members have agreed to a common strategic and operational approach to fighting terrorism. So this is the reason why every country is coming out with counterterrorism measures. What does the strategy do? The strategy reaffirms that member states have the primary responsibility to implement the United States global counterterrorism strategy. So the responsibility is of the member state because UN by itself cannot implement any of the laws in a country. And to prevent and counter terrorism and violent extremism conducive to terrorism. This sends a clear message that terrorism is unacceptable in all its forms and manifestations. And whether it is individually or collectively, one has to prevent and combat terrorism. Though practical steps include a wide array of measures, ranging from strengthening of member states' capacity to counter terrorist threats to better coordinating United Nations systems, counter-terrorism architecture and activity. Now, there are several, what I would call pillars or stratagems of the United Nations Global Counter-Terrorism Strategy. What do they involve? The security resolution of the UN General Assembly had the following specific points to be urged and implemented. Measures to address the conditions conducive to spread of terrorism. Now, what does this mean? This means that why does terrorism take place? Terrorism is nothing but exploiting a situation of dissatisfaction amongst a section of society and inciting them to take arms against what is the law and order in the country, against the democratic polity. So what should you do? In fact, I remember, I think the United Nations UNESCO declaration starts by saying, since wars originate in the minds of human beings, it is there that the war must be deconstructed. Similarly, terrorism originates in the minds of people. It is there that it must be deconstructed. Now, why is it that a person becomes a terrorist is something that needs to be carefully analyzed by social organizations, people who study sociology, people who study psychology and human behavior. And measures must be adopted to counter it at that level itself. Then the next is measures to prevent and combat terrorism. Now, in spite of that, there is terrorism going on. What measure should we adopt? How to prevent it even before it becomes successful is another strategy. Third is measures to build states' capacity to prevent and combat terrorism and to strengthen the role of the UN in that regard. Next is measures to address the conditions conducive to spread of terrorism. Next is measures to prevent and combat terrorism, build states' capacity, ensure respect for human rights for all and the rule of law as a fundamental basis of fight against terrorism. This is going to be a very interesting thing because human rights is something that everybody is entitled to. Our constitution guarantees, the UN declaration, UNHCR guarantees it. So, in the name of combating terrorism, Are we trampling upon the human rights? Are we trampling upon the fundamental rights of basic human beings in this country or any other country would be $1 million question which needs to be carefully addressed. Now, being a member state of the United Nations, India was obliged to enact appropriate domestic legislation to deal with terrorism. Terrorism, in its broadest sense, is defined as the unlawful use of violence or threats to intimidate or coerce a civilian population or government with the goal of furthering political, social, or ideological objectives. Now, look at the only facet of terrorism that you have been exposed to. First was the Khalistan movement, where the terrorists used to swoop down on villages, shoot people for no reason at all, place bombs on transportations, buses, and kill unnecessarily. Now, the other time we were exposed to was the Bombay Kali Poti, that fellow. That was also on 26/11, I think. When the attack was there on the Taj Mahal Hotel, then there was attack on the people there, that Khalid, what is his name? Khalid, no? The one the fellow who was ultimately hanged, the Pakistani fellow.
Ajmal Kasab.
Ajmal Kasab, not Khalid, no, Kasab. That Kasab, that was another terrorist activity. Now, please note, what were they trying to achieve, whether it is Khalistan movement or the Ajmal Kasab and his cohorts? What were they trying to do? They know that ultimately you're going to be caught and killed, or you will be shot down by the defense forces or the security forces. But in the meanwhile, they want to strike terror. For what purpose? For the purpose of propagating an ideological or political objective. These are, a bank robber also indulges in shooting. A dacoit also does shooting. But the dacoit's objective is to take money and run away from there. He doesn't care whether you have X kind of ideology or Y kind of ideology, or X party ruling you or Y party ruling you. But this kind of a terrorist wants to strike fear and say, unless you become Naxalites, there is no home for the country. Unless you become Islamic nation, there is no hope for you. Unless you become Khalistan, there is no hope for you. And therefore, in order to do that, they strike terror in it. How do they strike? Innocent civilians are killed. For no, they have nothing to know. They will tell you, I have nothing against you, sir, but I have to kill you because I have to achieve my political objective. That is what he will say. Because look at what happened in Taj Mahal Hotel. International tourists were there. Indian businessmen were staying there. Somebody enters with a machine gun and then goes duck, 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 duck. He has no enmity with any individual objective, but he wants to make a statement that what I stand for is the greatest objective, is the greatest ideological purpose. While serious and systematic attempts to understand and analyze the concept of terrorism in its entirety started in India in the 90s and has since then progressively intensified. The international community woke up to the reality of the global terror only after the 9/11. Now, what happened is we were given the first taste when Indira Gandhi was assassinated. Then we have the Rajiv Gandhi bombing. These were the two instances which shook up India. Now, if you ask any of the, who is that person, Nalini, who was convicted, whether she had any enmity with Rajiv Gandhi, she will say, I don't have any enmity with N.G. Gandhi. But this I wanted to do because I wanted to show that the Elam Tigers ideology was the best for solving the problems of Sri Lanka. And because Rajiv Gandhi was coming in the way with his peacekeeping force, we had to eliminate him. That's what she will tell you. And that is the concept of terrorism. And in the world, nobody really took it seriously. India has been a subject of terrorism quite often. I mean, I'm just giving you big examples, but whether you go to Kashmir or you go to Assam, that small incidents have taken place. The migration of all the Kashmiri Punjabi, Kashmiri Hindus, Kashmiri Pandits was precisely what was aimed by the Islamic terrorists. So that is exactly what confronted India. And then the world woke up thanks to the 9/11 in New York, when all of you know how they took a flight and went and banged into the World Trade Center and the consequence it created, it shook the world all over. After the 9/11 attack, that became the defining watershed in the international discourse on terror. It brought home the point that such acts of terror subvert the fundamental rules of law as well as deny the rights of citizens. They endanger the social fabric of the society and threaten its political as well as economic stability. It also brought in its wake the basic realization that all states, far or near, must always endeavor to proactively study the subject in all its manifestations and to empower themselves to deal effectively with all forms of terror without making any distinction. The fundamental argument that there was no distinction between regional terror groups and the newly coined terminology of global terrorist groups started gaining wider acceptance. After 9/11 incident, for the first time, we started hearing formulations like war against global terrorism, or better still, global war against terrorism, which these formulations entered the dominant discourse. So now today, terrorism is bad whether it happens in India or in the neighboring country or in the foreign country, because it is like something like your COVID. Whether it's COVID starts from China or goes somewhere else, comes in, we are all equally afraid. We had to take measures to prevent it. That is exactly how terrorism, global terrorism, has to be dealt with. Then this resulted in a new determination to deal with the threats and challenges posed by terror in all its manifestations. Legal brains in the world all over started revisiting the existing legal mechanisms to handle this new phenomenon. Now, please note, the Indian Penal Code also has several measures to deal with these kinds of threats. It's not that it is not, the law and order is always a problem. But these are measures which are intended to deal with acts at a lower level. Now, this is something that I remember while sitting as a judge in the Bombay court hearing criminal repetitions. I used to come across every day. Now, if a thief comes to your house at night and shows a gun to you or a knife to you in order to put you under fear and rob you, that's a law and order problem. That is not an act of terrorism. Because his motive is not to brainwash you into some ideology or political thinking, or for the establishment of some kind of different type of state or polity. He is only interested in short-term gain of money. You give him the purse, he will run away. Most probably he'll run away. Now that is strike terror for the purpose of gaining money. But if he comes and just for no reason throws a bomb at your house, I'm sorry, I'm giving examples and I don't mean anybody should throw a bomb at your house. I'm just giving you an example. Let's say throws a bomb at my house. That is terrorism, because then he says, hey, I don't care whether you are a judge or you're a lawyer or you're an ordinary citizen, but I want this country to be ruled by XYZ, Naxalite philosophy or Islamic philosophy or Khalistani philosophy or whatever that he wants to propagate. So this distinction has to be made. Now, unfortunately, way back when Macaulay drafted the IPC, I don't think they had concepts of terrorism as such. So they thought, yes, IPC dealt with it. You do some harm to somebody, bodily harm, their property harm, all that. IPC has nicely cataloged the different types of criminal activities, and then appropriately how to deal with them itself. The biggest problem about terrorism is that it becomes difficult to identify individuals because it's like a virus. Now, when the virus struck us, what did we do? We shut down the whole mechanism in the entire country. In fact, I remember there was in my own building, the first act that I remember in Mumbai was one of the boys was affected. And nobody knew what is to be done. People were so scared. They shut down my building, the police barricaded the building, put up a big notice there saying this building is affected. So I couldn't even get out, I couldn't even come to the window, I had to stay put. And we all know how we had to virtually closet ourselves during that entire period. That is exactly what happens in a terrorism situation. If somebody says that your neighbor's house was robbed, you'll say, oh, it's very bad. I hope the police have caught the thief, and then you forget about it. But if somebody says the neighbor's house has been bombed by terrorists, that strikes fear in your heart. And that is precisely what the terrorist intends. It is this striking fear in the population, the innocent population. It's I can understand war also strikes fear, but there you will say my Jawans will fight the other Jawans, and then there will be some kind of a resolution of the dispute. This is something like a virus. This is something that needs to be carefully handled. Unfortunately, IPC and other criminal acts which were on the statute book were unable to handle the situation because they were designed in the time when there was no concept of terrorism at all. Now, therefore, all the brains like Samiksha had to sit together and design and say, how do we solve this new problem? Now, another problem with terrorism and gangsterism is you can't find what is a normal law and order situation. Somebody does something which is a criminal activity. Police investigate, catch him, charge sheet him, then the trial goes on. Evidence is recorded. He is found guilty or not guilty, whatever the court does. Now, in a situation where there is terror, nobody is going to come and give evidence. So if somebody has seen, he will say, I'd keep quiet, otherwise tomorrow the bomb will be on my head. So that is the whole purpose of that, saying that you strike fear into the populace so that the populace will A, not dare to come and give evidence against you. B, the populace will say, whatever happens, we'll accept your ideology. That is the purpose of terrorism. So all the legal brains all over the world started thinking and saying, hey, these old mechanisms that we already have in existence are incapable of dealing with the situation. So what do we do? Like all the master brains who came out with new vaccines. The vaccine was not there before the COVID started. They sat together, worked on that and came out with a new vaccine. Similarly, they had to come out with new counterterrorism measures. Now, in India also, but one thing is there. When you come out with a law which has to deal with a drastic situation like an act of terrorism, there is bound to be some amount of infringement of the fundamental rights of human beings. Now this becomes a delicate balancing affair. How far do you infringe the basic right and how far do you protect the basic rights? This is the dilemma of the court, the dilemma of the judge in every matter where there is a harsh law which operates. In India also, for a long time, we had not paid adequate attention to the enactment of any specific enabling domestic legislation to deal with terrorism. The effectiveness must be that the law should be capable of denying an operating space and maneuverability to terrorist groups and their support structures, which would deter them from executing any acts of terror. So this strategy is something much more than having a law book saying that this is an act of terrorism, this is how it is to be punished. Their strategy should be, how do you counter it psychologically? By propaganda machinery. How do you counter it? By sociologically, by advising people constantly digging into their heads that this is not going to work for them. This is actually going to work against their interests. And of course, a mechanism which will ensure that these groups don't suddenly come together and start working. The biggest is funding of terrorist organizations, which is the biggest threat. Therefore, how to find out what are the strategies by you identify such terror funding and kill them then and there. So we had to have this kind of strategy. It's it's an octopus strategy. It's a multi-pronged strategy which has to operate at different levels so that it's like killing a hydra-headed monster. So all the tentacles have to be chopped off. Then consistent and effective anti-terrorist policies and counter-terror mechanism demanded strong national consensus and commitment as basic requisite. Now, fortunately or unfortunately, law and order is a state subject. This is an interesting thing which leads to all kinds of problems. So each policing is an state subject. So each state says, hey, look, under the constitution, it is exclusively given to me. So you can't step into my jurisdiction. So I am not interested. I will not do any of this. Now, one state may say, I am affected by terrorism. They want to have this kind of law. Another state may say, I am not affected by terrorism. I don't want this. My citizens should have absolute full freedom of exercising their basic rights. So in a situation like this, how does one deal with the problem? The problem becomes more complicated because of the federal nature and the fact that the law, order, and police mechanism is in the state subject of the constitution, which is exclusively reserved for the purpose of legislation activity by the state. So then, this dawning realization or growing realization that terrorism is something that cannot be dealt with by ad hoc activities, ad hoc solutions, but there must be a national consensus to it, was something that is growing up in the country after we lost 2 prime ministers to terrorist activities. Then we also realize that the penal provisions that are there in the major laws, such as the IPC, Indian Explosives Act, Indian Arms Act, and such others, were good procedurally, but the provisions, because they would fall back on the procedure in the Criminal Procedure Code, and that was found inadequate to deal with the subject of terrorism, to contain it, so I to say. In 1985, in the aftermath of Prime Minister Indira Gandhi's assassination, for the first time, the government enacted what was known as the Terrorist and Disruptive Activities Prevention Act, or known as TADA. TADA was such a political hot potato. I remember that. In the hope that this would act as an effective omnibus law to deal with the issues nationally and put an end to terrorist activity. This, however, did not happen for various reasons. Eventually, Tata ran into hot weather. Tata ran into serious difficulty because, you see, what happens is, I think it is Lord Acton in England who said, power corrupts and absolute power corrupts absolutely. Tata gave them absolutely unlimited power. Now, all counter-terrorist measures have these special characteristics. What are they? Normally, there is presumption of the innocence of the accused. In a counter-terrorist measure, the presumption is always the other way. Number 2, liberality in granting bail. That is totally denied. Then the period for which a person could be kept under detention without being brought to trial, that was limited by the provisions of the Criminal Procedure Code. The limitations were there. They were also relaxed. And then I cannot be declared to be a terrorist unless there is a particular mechanism followed. Unless I am found normally under guilty of a terrorist act. But these acts gave them power to say that you could declare a person as a terrorist and then subject him to various kinds of stringent measures. Now, the police and the state machinery used it most wrongly for political ends. This always happens when too much power is always given. So what happened? There was severe criticism. Tada was called. Every city had some kind of Samiksha Singh organizing a seminar and saying Tada is bad, kill Tada, Tada is bad, repeal Tada, repeal Tada, repeal Tada. This happened so much that finally the country continued to reel under the exponential rise in terrorist activity on the one hand, and in different parts of the country, Tada was not likely to solve the problem. Now, interestingly, Tada was challenged, legally challenged, all the way to the Supreme Court. And the argument was, hey, look, you can't apply this throughout the country because law and order, police is a state subject, and central government has no right to legislate on this. The Supreme Court, as usual, was given a puzzle to solve. They looked around and said, okay, ordinary law and order, we understand it is a state subject. But if it is something that has to do with the sovereignty of the country, integrity of the country, and public at large, at a very large level, that affects the country as a whole, then no, it falls under one particular item, which is under the list one, which is union subject. And also, they also said it falls under the residuary item 97, wherever there is no other power anywhere, central government can enact. So they upheld by this kind of curious reasoning, Supreme Court upheld the TADA. But still, constitutional validity having been upheld, the police became emboldened. They started left and right first. In fact, I'll tell you an interesting story. I was sitting and doing criminal hearing of criminal petitions in Bombay High Court. At one time, there was this girl who was the usual lover stiff. The girl did not want to carry on with the boy, and then she said, nothing doing. What is the expression? I'm breaking off. Huh? She broke off. I'm sorry, I'm not used to these expressions. I've started learning them very recently from my children. She broke off. This lover boy chased her, and then he took a gun or a knife or something and raped her. Now, the police charged him with all the relevant sections of the IPC and Section 5 of TADA. So when the matter came to me, I said, how on earth is this TADA? The prosecutor gets up and tells me, sir, what did he do? He took a gun and terrorized her and raped her. Therefore, it amounts to a terrorist activity. Now, this is the extent to which the police went. What should have been normally dealt with by the regular criminal procedure code, read with IPC, or any other supporting legislation, they started indiscriminately using TADA. Because the moment you say TADA, and he declared him to be a terrorist, then the court will say, no, I'll not grant you bail. I'll not grant you bail unless I'm satisfied that you are not likely to be guilty. What is this? The presumption is the accused is presumed to be guilty unless he is proved otherwise. And bail was not there, and all this happened. So TADA ran into a lot of political extreme weather. Because of this, then ultimately it was allowed to lapse. But once they say no, they say about the tigers, once they have tasted blood, human blood, they can't eat, they will not enjoy other animals, they want to come back. Adamkhor, the Adamkhor share philosophy worked it. Once the government had tasted, the police had tasted it, they wanted it back. So TADA in its new avatar was called POTA. POTA is Prevention of Terrorist Activities. There, of course, there was some kind of concession made. The TADA was given some kind of makeover and then became POTA in 2002. This is the direct result of the December 2001 brazen attack on the parliament by the externally sponsored terrorist activity. That was another terrorist activity. But POTA 2 was short-lived. Same problem with POTA also. And it was repealed in 2004, almost on grounds similar to the TADA. TADA was enacted in 1985. POTA was enacted in 2002. Both laws were aimed to combat terrorism, but they face criticism for potential misuse and human rights violation. Here I must tell you something interesting. Both while upholding TADA and POTA, it was only TADA. In Kartar Singh's case, Supreme Court said, yes, this is very harsh law, but we must trust the police authorities. We must trust the government to act in a humane manner. This kind of so-called trust by the Supreme Court has never proved to be a success. Now, if you remember the famous judgment of what is that? ADM of Jabalpur case. I don't know how many of you are born at that time when the judgment was delivered, but that judgment became heavily criticized, and ultimately it has been repealed by the Supreme Court later by the son repealing the father's, redeeming for the father's mistakes. Now, what was it about? Upholding such a drastic law and the constitutional amendment, various kinds of powers of under the constitution being chopped off. On what ground? On the ground, what is it? The sentence was because the Supreme Court had a diamond hope and a diamond bright, shining bright, something like that, that the government would act as the Mata Pita, my Baap of the citizens and take care of them. Now, did it come true at any time? During the emergency, we saw how harshly people were treated and how their fundamental rights were trampled upon. So this is the reason why harsh laws are opposed by uniformly by everybody. Because this is something uniform. Now, I'll tell you an interesting thing. Today, everybody hates Income Tax Act. I'm sure you also hate it. But how did Income Tax Act start? Income Tax Act started as a wartime measure during the Second World War. British government wanted to raise money. There was no income tax before that. If I were born before that, I would have been a happy man. But Income Tax Act said, no, let's collect some money on this ground for war measures. Now it has become a permanent feature. Now nobody can say Income Tax Act is temporary income tax. Another thing, the tenancy laws, they were also temporary and extended from time to time. Similarly, so tada gaya, pota aa gaya. Then pota jayega, something else will come. This will continue. The only question is, have a balance sheet. These are harsh measures. How much of the basic fundamental rights, human rights, are you trampling upon? How much of it is necessary? The Supreme Court called it the doctrine of proportionality in Puttaswamy's case when upholding the Aadhaar card. Okay, now we come to but after Tada went away and Pota came in 2002, both were intended for a good purpose of combating terrorism, but they faced criticism for potential misuse and trampling of human rights violations. Then Pota was repealed in 2004, and Tada has already been allowed to repass. So for about a 4 years period, there was no anti-terrorism law in this country. We did not have any special federal legislation to deal with acts of terror facing the state governments to enact similar enabling laws. So during this 4 period, states said, okay, there is no federal law, we'll enact something. So someday the Makoka or whatever, the Maharashtra thing, and the Gujarat came out something, Karnataka came out something. They didn't call it terrorism, they called it something, what is that expansion of Makoka, Maharashtra, anti-criminal activity, something of that sort. MCOCA, followed by states of Karnataka and Chhattisgarh also had one law, and others. The state of Gujarat too attempted a special legislation which did not see the light of the day, since possibly for political reasons it failed to receive central government approval. Now, as a result, while on the one hand, acts of terror continued to multiply in numerical terms, they became more and more serious and brutal in their impact. The investigating agencies remained largely dependent once again on the provisions of IPC and CRPC. The question that naturally kept cropping up and daunting the security establishments was whether India should still continue to deal with cases of terrorism on the basis of the existing legal mechanism, or was the time ripe for coming out with our own counter-terrorism measures, which would be comprehensive and override anti-terror legislation with all India jurisdiction, dealing in an inclusive manner all aspects of investigation and prosecution in terrorism-related cases. It is in this context that it became necessary for them to look around. The government looked around, and what did it see? That even in countries where there was, which upheld democratic rights and basic human rights, there were these kinds of laws. They were in UK, the USA, European Union, Israel, and global entity of the Union. All of them were members of the Union, but they had somewhat harsh anti-terrorist laws. These deliberations and the fact that all over the world there was new kind of awakening of adopting counter-terrorism measures led India to also to come out with law. But unfortunately in India, our legislations are all knee-jerk legislation. Arey, aaj kuch ho gaya, immediately law banao. I always say this, and I'm sorry, it may be criticism of the government, but it is criticism coming out of a sense of responsibility that we are long on laws, but short on implementation. Even take the IPC. How many cases are really investigated? How many cases where people ought to be in jail are not in jail? And people should not be put in jail or put in jail and not granted bail. Even forget the counter-terrorism measures, even ordinary laws. So people were somewhat skeptical about these things, saying that, hey, even with ordinary IPC implementation, you mess it up so much. If I give you a harsher, stringent measure like counterterrorism measure like POTA or whatever, TADA, POTA, or it's something in the same genealogy, you will really trample upon the human rights and basic rights of the Indian people. Now, the counterterrorism laws, they have a certain amount of common features. What do they? They define various terrorist acts, including bombing, hijacking, attacks on sovereignty, integrity of the country. In fact, the UN has passed several legislation resolutions on each of them about hijacking, which became a nuisance. They came out with resolution. Then bombing, they came out with the resolution. Then attacks on sovereignty and integrity, they have come out with resolution. Then conspiring, recruiting, and providing support for terrorism are also covered under the legal framework of anti-terrorism law. Now, all of them have these kind of common features. First, the reversal of the presumption of the innocence of the accused. The rule is reversed. Then stringent punishments are there. The laws prescribe severe penalties, including imprisonment, in certain cases, death also, for individuals involved in terrorist activities. And there are special courts to try them with special expedited trial procedures to ensure swift justice. Now, when you analyze the evolution of the anti-terrorist law in India, you come across these kinds of developments. Now, first you came to TADA. The TADA was enacted in 1987, primarily to deal with the terrorist activities in India, which originated in Punjab and the Khanistan movement at that time. It featured stringent provisions like denial of bail, reversal of the presumption of accused, and then stringent punishment, etc. TADA was challenged as unlawful unconstitutional before the Supreme Court in the Kartar Singh's case. The Supreme Court of India maintained its constitutional legitimacy on the presumption that individuals given such draconian statutory powers would act in good faith and for the benefit of the public. Please notice, this is where the Supreme Court has been misled for a long time. However, there were several examples of the abuse of power for unintended consequences. Law enforcement authorities began to exploit the strict guidelines outlined in the statute. In 1995, TADA had to be withdrawn because the police officers started charging for Section 5 of TADA in petty cases like a pickpocket TADA. What is this? TADA was intended for dealing with terrorists. No, pickpockets and somebody who steals money from your house is not a terrorist in such. Then, as I told you, TADA was gone, POTA came in. It was necessary to enact a special law to deal with terrorist activities due to the increase of cross-border terrorism. The Pakistani ISI's ongoing offensive program, how they were engineering terrorist skills and then pushing into across the porous borders, which was aimed at destabilizing India, and the developments following terrorist attacks of September 11, 2001, our famous September 11. The Prevention of Terrorism Act of 2002, or POTA 2002, was consequently passed and announced. In the judgment in PUCL versus Union of India, a similar challenge to TADA was raised. The constitutional challenge is, but Supreme Court again rejected it on the same ground, saying no, it is necessary because it has to apply all over the country, and its constitutional validity can be sustained. The power can be read in list 1, read with residuary item 97. The United Progressive Alliance made it a election plan, saying that if we come to power, we'll repeal POTA. Now that went on, and groups defending civil liberties and human rights battled against it. During the 2004 election, the UAPA government went on saying that no, we will repeal it if we come into power. But such things never happened. The election promises are election promises. Then, while all this was happening, states also started coming out with this kind of legislation. The Maharashtra Control of Organized Crime Act 1999, which went into effect on 24th of April 1099, is another significant anti-terrorist statute in India. The underworld in Mumbai and the growing organized crime in Maharashtra were the main driving forces behind the creation of this law. MCO, the Mokoka definition of terrorist act is much broader than even your POTA. And the term organized crime is mentioned in Mokoka, which also classifies promotion of insurrection as an act of terrorism. According to Maharashtra law, until a person, this is the unfortunate thing that has happened, until a person can demonstrate his innocence, he is believed to be guilty. So the presumption of innocence of the accused is gone. The moment they charge X or Y or Z with Makoka, then he is presumed to be guilty unless he can demonstrate that he is not likely to be guilty. Excuse me. According to Maharashtra law, Makoka does not mandate those police. The interesting thing is, if any one of these laws had a provision that for wrong use, the police officer will be responsible, things would be better. Police would act in a responsible manner and not indiscriminately use the harsh law. But none of these acts ever bothered to say that. Then came the Unlawful Prevention Act, the current anti-terrorist law which applies all over the country, the UAPA Act. The UAPA was not a terror law from 1967 to 2004. It was not intended for an anti-terrorist legislation at all. In December 2004, Parliament added a section on criminalizing terrorist acts. The Manmohan Singh government introduced Chapter 4 of the UAPA Amendment Act 2004. The UAPA was further modified in 2008 and 2019 to broaden its application. And they added this definition: whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or economic security or sovereignty in India, or with intent to strike terror in the people, or likely to strike terror in the people of India or any foreign country, is now defined as a terrorist act. In section 15 of the act, and section 15 says such a person will be said to be committing a terrorist act. These specific laws are interpreted by courts using different sections of the Indian Penal Code 1860. I don't know how they are justified in doing it. The UAPA today is the primary legislation in India that deals with terrorism-related offences. It provides for the declaration of an organization as unlawful if it is involved in terrorism. Now, this was something new, it was not there earlier, so they can take an organization and declare it to be a terrorist organization. Then individuals associated with such organizations can face stringent legal consequences, including, supposing I am a member of some association, and if that association gets declared to be a terrorist association, a terrorist organization, by the mere reason that I am a member of that, I'm likely to be called a terrorist and subjected to penalties under the Unlawful Prevention Activities Prevention Act. Then, this was also challenged. And as usual, Supreme Court said, no, it is necessary, otherwise terrorists will overrun the country, blah, blah, blah. Having succeeded before the Supreme Court in sustaining the constitutionality, the central government went ahead to introduce another amendment to the UAPA in 1969. UAPA is 1967, in the year 2019, after the present government took over. Now, they brought in a couple of changes to the act. Firstly, they established a National Investigative Agency, which is established by a separate act known as the National Investigative Agency Act 2008, NIA Act, which has unrestricted power to perform searches, seizures, and make arrests in any state of the country without having to inform the state government or the local authorities about the same in advance. You see, this is an interesting thing. The CBI had similar powers, but the CBI power is stopped because unless the state agrees to it, you can't come into a state and do that. Now, to overcome that difficulty, Parliament has now taken advantage of Supreme Court's upholding of constitutionality in Kartar Singh and again in the POTA Act, and now says, no, this is a federal law which will apply throughout the territory of the country, which is necessary for us to uphold the integrity and sovereignty of the country. And this NIA has unrestricted power to carry out searches, seizures, and policing all over the country. This change, originally, the NIA had to intimate the state government in advance, the state police in advance, and saying, hey, tomorrow morning I'm coming to catch a terrorist there. Now, giving such advance notice to a terrorist is of no use, because by tomorrow morning the terrorist is not going to be sitting there waiting for you to come and catch him. So now they can barge into any country or any state without the state government's permission and carry out the searches and seizures and arrests because the law has empowered them. Now, this change is believed by some of the legal luminaries is for better instead of the strife with Maharashtra government, which demanded advance notice about arrival and operation of NIA. NIA always found it difficult to conduct secret and confidential searches and operations, resulting in terrorist activities not being curbed. The NIA Act established a National Investigation Agency, which is a specialized agency to handle terror-related cases. The NIA has jurisdiction across the country and take up cases involving terrorism without requiring permission from the states, unlike the CBI. Instead of the conflict with the Maharashtra government, which wanted advance notification about the entry and operations of NIA, this modification has been thought to be better because it helps in curbing terrorist activities in the state. Now, one more thing was done. A fourth schedule to the Parent Act was introduced. The Parent Act being the Unlawful Activities Prevention Act, which gives the union government unrestricted power to add or remove any person to be designated as a terrorist and detain the said person for up to 2 years without any provision for a judicial appeal. This is some drastic power which has been invested with the NIA as a result of the fourth schedule being added to the Unlawful Activities Prevention Act. This second amendment, which involved changes to Section 35(1) of the Parent Act, opened floodgates of controversies. Soon, several petitions contesting the newly inserted clauses violating Article 19(1) and Article 21 of the Constitution were filed with the Supreme Court of India. The Supreme Court was asked to impose the temporary doctrine of eclipse while determining the constitutional validity, the legality of the amendment of the Act. Now, when you analyze all the anti-terrorist act in India, there is one thing that stands out, that an act of terror is codified in multiple entries of the Constitution, especially entries of the 7th schedule, where offences pertaining to defense of India and offences against armed forces of the Union India are listed. The preventive detentions related to defense of India, foreign affairs, and security of India are also mentioned in entries 1, 2, and 9 of the list of the schedule, respectively. The first and second entries of the state list provide the guidelines about the issues related to public order and police, which are the prominent functions of a state machinery. The listed entities mentioned about policing and public order are often used to prosecute the offences related to terrorism, which is somewhat nebulous and doubtful. The ambiguous part is this. Criminal law, criminal procedure, and guidelines about preventive detentions affecting public order are mentioned in the first, second, and third entries of 7th schedule. Consequently, this serious ambiguity is often used by various entities to challenge the legislative competence of the federal legislature for preventing terrorism at various stages of proceedings in the courts of law. Nevertheless, it has been observed that the union government retains the power to enact anti-terrorist legislation thanks to the Supreme Court upholding the constitutionality uniformly in TADA, POTA, and UIPA. Again, Kartar Singh was the TADA, upholding TADA. Then we have, because of the parliament, Supreme Court at that time was impressed by the fact that the terrorism activities in Punjab were going beyond control. And therefore, they had to uphold the legislative competence of the union government. Otherwise, Punjab was as good as seceded from the government of India, from the Union of India. Whenever such attempts were made, by projecting the argument that the jurisdiction of such a legislation falls under the entry upon a state list, the legislative competence of the parliament was challenged. The Supreme Court endorsed the competence of parliament in enacting anti-terrorism legislation like TADA In support of its judgment, the court also explained that public order falling under entry 1 of state list relates to offences that are considered of a lesser gravity. Further, the court clarified those serious incidents or crimes driven with the object to challenge the integrity of the country and threaten the security of the nation should be considered as a whole. Thus, they can be considered as a part of entry 1 of the Union list, which delineates about the defense of Union of India. It also falls under the residuary power conferred to Parliament under Article 248, added as entry 97 in the Union list. Then the Supreme Court pronounced its verdict after a detailed analysis of various legal provisions and reached the conclusion that it upheld the argument in support of Parliament. It also considered that offences listed under TADA were grave in nature. It may further lead to a situation where the security and integrity of the country as a whole may be challenged by various non-state actors at the borders, or by some anti-national elements within the country, posing greater challenge to the sovereignty. These are the reasonings by which the Supreme Court upheld TADA. Again, it's applicable, and right up to the present UAPA, this will continuously apply. Now, these anti-terrorist activities have engendered some challenges, some issues. What are those issues? Human rights concerns. Critics of these laws argue that some of the provisions of anti-terrorism laws may infringe individual rights, leading to concern about arbitrary arrest and detention. That is the biggest concern that international agencies like Commonwealth Human Rights Watch and such other human rights agencies, the NHRC, have constantly voiced. Then there is misuse of laws. Misuse of laws I have seen as judge in so many cases. There have been instances, I would say many instances, where anti-terrorism laws were allegedly misused for political purpose, leading to arrest of individuals without. Now tomorrow, if somebody comes and says, I'm arresting you, the NIA says, I'm arresting you because your activities are threatening the sovereignty of the country. I can't get bail. Now, how do I am going to prove to the judge that I'm going to be innocent? I'm going to be ultimately acquitted in trial. That trial will take place after 10 years, and then I may be acquitted because there is no evidence. But then the state has effectively silenced my voice. Why I was put up in the first place? Because I kept on criticizing something or the other that the state has done. Such attempts are serious concerns according to people who analyze these laws, people who think. Then there is a need for balance. Striking a balance between maintaining national security and protecting individual liberties has remained the biggest challenge. It is essential to ensure that these laws are not used to suppress dissent or target specific communities. This is the biggest worry that we have today. Then there are several controversies surrounding the UAPA. Bail is challenging under the Act. Terror law. Bail can never be granted, is 99%. Normally, I remember there is this famous dicta of Justice Krishna Iyer, that what is it? Bail and not jail is the rule. Now it is the other way. Jail and not bail is the rule. So wherever you ask for bail, the bail is rejected. Even in ordinary cases. So if it is an anti-terrorist law, you can be sure that you are not going to get bail at all. See what happened in the case of that the Bhima Koregam accused. They're still sitting. One of them who died also in the in jail because he was not granted bail. Then the pre-charge sheet custody period is increased from 90 to 180 days. That what is that called? 90 days, if you don't charge sheet him, he is entitled to automatic bail. That is increased to 108. In 6 months, they can make you sit in jail without anything. Additionally, UAPA limits the use of bail and requires the court to base its determination on the accused's guilt on police records. So they say, look at the record that we have got, look at the evidence that we have dug up. Now, whether it is true or not, nobody has decided. The probability is he is not going to be acquitted, therefore he must not be granted bail. That is the test that the courts now, special courts apply. In UAPA, there are far too many convictions. That is why you find the convictions are zero or maybe marginal. Data from the Union Home Ministry shows that was provided to Parliament, not to me, but to Parliament, shows that 2.2% of the cases filed under the UAPA between 2016 and 2019 have ended in convictions. So that means the other 87.8 cases were cases without any basis. Comparing it to other criminal systems, the USA only permits a custody period of 7 days. Australia gives investigating agencies 24 hours to demonstrate their case for prolonged incarceration. Now, these are some of the controversies that have been raised about this UAPA, which is the reigning act today as the counterterrorism law in the country. Now, let's look at the conclusion, what has happened. How was things analyzed on the ground level? While we may conclude that the anti-terrorism law and its application might require a lot of changes, scrapping it off totally increases the threat to national security to India as a big player in South Asia. You know, India is the only one who has been affected by these kind of terrorist activities in entire Southeast Asia. Having neighbors with unstable governments and military regimes. Consequently, we as a nation are troubled with an influx of terrorism, and hence a law for its prevention is absolutely necessary. Such a law will also have give more free hand in limitations on fundamental rights than other acts and laws, considering its gravity and importance to the very security of the nation. There's some. What do you think? Jaan hai to jindagi hai. So ye jaan ke sawal hai, therefore there must be some method. Security and integrity, sovereignty must be first maintained, and then we talk of other rights. However, a confidence building program for citizens should be underway to remove their apprehensions against the act, while a possible reform or a thorough investigation is carried out against its discrepancies and possible misuse. Terrorism prevention laws are important, as the greatest approach to the police to stop terrorism or an insurrection is to prevent it from growing. Only swift and impartial application of the law in response to any indication of a developing scenario will be able to achieve this. Once it has reached this point, the situation is far too complicated for the police to handle without the aid of security personnel and the use of special legislation. Counterterrorism strategies are a mix of diplomacy and political and military efforts. So it should be a question of where the terrorism begins, there you must deconstruct it. Still, India primarily focuses on using force, which leads to failure and further aggravates political violence, which needs to change. This is the problem in India. There has been excellent research done, undertaken by an organization known as Vidhi Center for Legal Policy, sometime in 2015 June. They prominently focused on certain key issues like federalism, issues that affect the center state synergy, laws governing terrorism-related cases, judicial interpretation of anti-terrorist law, and certain procedural issues. Their findings are like this. One, the basic statutory approach to terrorism has not changed since Tada, resulting in the language and structure of subsequent status largely being based on this law formulated in the 80s. This is despite the nature of terrorism and counter-terrorism effort having undergone sea changes in the supervening decades. So the thinking on terrorism and counter-terrorism mechanism between 80 and 2024 has changed, but the laws have remained stratified. Number two, the haste in legislating anti-terrorist laws led to a significant amount of incoherence without substantial thought being given to the unintended consequences of the slight tweaks of the language. Thus, these problems in the language of statutes contribute to a delay in the disposal of terrorism trials. The next anti-terrorism laws have been made without studying the misuse and impact of Tada and Pota, thus increasing the chances of their misuse. See, this is exactly the point. All right, Supreme Court had to take an ad hoc view that will uphold the constitutionality. It is not that the complaints which were made about misuse were not justified. But then the question is, what are the circumstances under which the misuse happened? How do we stop the misuse happening in future? How do we design a law which takes care of there being no misuse, but at the same time takes care of curbing terrorist activity. Now, has any study been made in the country? Has Parliament constituted it? Was there any debate in Parliament on that? Did the JPC go into it? Nothing of the sort. Simply one day they said, okay, Tada gaya, Pota gaya, UAPA aaya. So UAPA will go, something will come. Every time there is haste, that's why I said it is knee-jerk and ad hocism. Without studying an issue which is really deep structurally. Then similarly, special courts have been set up under various anti-terror laws, which have been unable to expedite the trial of the accused under these laws, and in many cases have instead undermined the due process in the fair trial. Because they have this power, say, I'll deny the bail, I'll deny you this, I'll deny you that. And the trial does not, I can understand if tomorrow morning you are going to try and dispose of the trial, fine. You won't take up the trial for 10 years, what is the use of saying that I'm going to be sitting in jail? However, the extraordinariness of anti-terror laws has been insufficiently explored in judicial reasoning in India, which has resulted in a situation where the undermining of civil liberties is slowly becoming the norm instead of the exception. These deliberations signify, this is my conclusion, these deliberations clearly signify that in India, various legislations constitute the knee-jerk and ad hoc responses of the union and state government to acts of terrorism. However, the interface of application of these multiple laws and the investigating agencies expose a strong possibility of conflicts. The counterterrorism laws define various terrorist acts, including bombing, hijackings, attacks on sovereignty and integrity of the country. And I already pointed out to you that in each of these species, UN has come out with a resolution. The question is, you must apply your mind to this and come out with a particular legislation which suits it with balancing, act of balancing. Then striking a balance between maintaining national security and protecting individual liberties remains the greatest challenge today. It is essential to ensure that these laws are not used to suppress dissent or target specific communities. And finally, in conclusion, I would say the fight against terrorism requires a delicate balance between safeguarding national security and upholding individual rights. India's anti-terrorism laws play a crucial role in this effort, providing legal mechanism to identify, prosecute, and punish those involved in terrorist activities. However, continuous scrutiny, review, and refinement of these laws are necessary to address the serious concerns about human rights and prevent potential. This, ladies and gentlemen, is my view of the terrorism, acts of terrorism. I think I have sufficiently terrorized all the audience with this long lecture. No. If they can terrorize me with some questions, some questions I'm willing to answer them. But please modulate the questions. Otherwise, the questions tend to become counter lectures.
Thank you. Thank you so much, sir. It was a very thought-provoking session, to say the least. I'm all set with my notes. Due to paucity of time, we'll be taking up a few questions and I'll be clubbing the questions which are similar in nature. So the first question is from Hitanshi. She is a PhD scholar.
Yes.
So she wants to ask about how artificial intelligence would impact terrorism and it would foster the national security issues, in your opinion.
Yes. Hitanshi, artificial intelligence is not a solution to every problem of the human being. What is artificial intelligence? Have you studied how does artificial intelligence really work? Artificial intelligence works on paradigms. You feed in data of millions of bits, and because of machine learning, the machine seeks to establish a pattern. And from the pattern, it can say that, oh, so many times it has happened in the past, in the future also it will happen like this. But can you say that of a human being? I doubt if anybody can say, then that will be very easy, no? My father was a good lawyer, so what is the guarantee that I'll be a good lawyer? I may be an idiot. And what is the guarantee that my children will be good lawyers just because the patterns happen? Therefore, artificial intelligence is useful. It may be useful for the purpose of identifying foci where such counterterrorism is breeding. It may be useful for identifying instances where terror funding is going into the country. because you will have to analyze millions of bytes of data in order to understand how the money is coming in, what are the various conduits and all that. But anti-terrorism as such is born here, and AI cannot change this. If AI changes this, then there is no answer to that.
Thank you, sir. So the next question is from Pragadish. He asks, in the light of terrorist act being defined under the new Bharatiya Nyaya Sanhita Act, once it comes into force, what could be the possibility of the law which will affect the innocents? Considering the fact that the officer whose ranking is SP or above would have a discretion in filing of the cases either under the UAPA or under the BNS.
That is a more dangerous situation, according to me. If they had told him that, no, you follow only one law, it would have been simple. Otherwise, he will say, who is B and Sri Krishna? Sri Krishna is a political activist. Therefore, I will apply the terrorist law to him. Somebody else will apply the ordinary law. See, the whole problem is this. Anti-terrorism is a measure in order to ensure that terrorist activities are curbed. As long as the police have a discretion in deciding whether it is so, you have no, whether it comes under this head or that head. If it slaps, the point is this, under the, what is it, Bharatiya Nyaya Samhita. I can't even remember the new names. What is it called?
Bharatiya Nyaya Sanhita, sir.
Under the Bharatiya Nyaya Samhita, is the definition different from the definition under the UAPA? If the definition is different, then the question next is the mechanism of punishment, trial, bail different under the UAPA as against the Bharatiya Nyaya Sanhita? If it is, then you have to show to the court and say, why is it that you are not proceeding under the regular Samhita and you are proceeding under UAPA? There must be some reason. And easy for the accused to say it's political. And it's again problematic for the court to say whether it is political or not. Therefore, the judge should be in a position to say, why on earth have you charged him with X act as against Y act? Why this stringent provision as against this? There must be some answer given to that. And if the judges act toughly, then this problem will not be there. But if you leave it to the SP, just because he holds the rank of SP, hello, even if you hold the rank of Director General of Police, this question arises. I'm not bothered about the rank of the SP. The question is one of the state acting through its very officers as against an individual. So if the state has done and picked up the terrorist act and slapped him with the terrorism, act of terrorism, why has it done? There must be cogent evidence. That evidence should be shown to the court. If the court is satisfied, it will say fine. Otherwise, it will say throw him out and say prosecute him under the record. I give you the example of somebody being raped and charged under Tada.
Right, sir. So next question we have from Samriddhi. She asks, should the instances of mob lynching, etc., that are meant to instill fear and essentially a chilling effect on the targeted communities should also be seen as acts of terrorism because they are also done with a certain agenda?
Perhaps you are right. Who is this Mansi?
Samriddhi.
Samriddhi, God bless you. Samriddhi, what you are saying is right. In fact, that is my thinking also. Act of terrorism can be by somebody who is trying to overthrow the established rule, government established by law, or somebody who is trying to induce different kind of political thinking or social thinking or even religious thinking among persons. So, if they had a strict judge, he could even say, yes, this is a terrorist activity, why not? It's easy, the definition is so wide, you can easily fit into it. And I wish some judge would take the bold step of doing it.
Right, sir. So Nishant asks, do you think India also needs a separate legislation on the lines of UAPA or NSA to stop social media propaganda and brainwashing through fake news and pro-terrorist narratives? Such legislations can stop the cultivation of terrorism from the root right from the beginning. We've already seen that whenever a riot happens in India, investigation points out to the roots that lie in the social media and brainwashing.
See, the point is, social evil can never be dealt with by legislation, whether it is Portal or TADA or UIPA. Social activities have to be dealt with at a social level. There should be a engendering of thinking saying that it is wrong. Very well. Now it's a question of social media. This is not new thing. No? Social media was not even invented at the time of IPC. Now, social media is already subjected to all kinds of curbs under the IT Act. When the Data Protection Act becomes applicable, that also has inherent built mechanism. Now, why should they be brought under the Terrorist Act? I didn't understand. Yes, probably propagating terrorism on social media could fall very much into the Terrorist Act here. The definition is wide enough. If you say, let's say, on the Facebook or X, what is another thing? Or
Twitter. Now it's become X. Instagram.
Instagram, you say, we should bomb the whole of this community, something like that, right? That can fall straight square, but why do you need another act? This act is sufficient. I mean, don't keep on inventing acts. Use more effectively the existing ones.
Correct.
I'm sure if a judge is careful and creative in his thinking, he can convict a person under this act itself.
Right, so. So we have a question from Narayani. She asks, how does India address the issue of under trials, particularly in cases where the individuals are accused of terrorism or association with terrorist organizations? What safeguards are taken in place to ensure a fair balance between expeditious legal proceedings and protecting the rights of the accused or those who are found innocent in these severe cases?
This is the problem. As I pointed out, the statistics show that only 2% or 2.2% of the cases actually result in conviction. That means the balance, the 97 and odd, are just hanging in, and who knows the trial. Therefore, the right thing to do is to ensure that the trials happen then and there. Now, how do you ensure is the million-dollar question. I'm afraid there are too many problems there. One problem may be there are not enough courts to hear such matters. The investigation is scrappy. Now, if the investigation is based on pure scientific methods, it will be over in short time. Now, I have sat on the criminal bench in Supreme Court also. Now, what happens? Forget trial cases of terrorist activities. Ordinary IPC case. What is the case? Somebody was shot with a gun and he died. Case of murder. The first thing that you would have said is, seize the gun, send it for ballistic reports, find out whether the bullet is extracted from this. That is scientific evidence. I don't need a witness to say, I saw him pull the trigger. Nothing of the sort. This is scientific evidence. Thumb impression, scientific evidence. Blood group, scientific evidence. And my uniform experience sitting in the Supreme Court was, there was no ballistic reports produced, or the ballistic reports did not come until the trial was open, or the forensic report, the laboratory said the sample of the blood was deteriorated, so we can't identify the blood group. But this is in deficiency in the law, deficiency in the court, is deficiency in carrying out the work. Now, if you don't have sufficient forensic laboratories available to do too much, today you send the blood group, within 1 week it should be ready. The trial will start immediately. Why not? These are bigger issues. Now, I cannot answer it by saying, but change the law and say trial should start tomorrow. Is it possible to start tomorrow? The whole point.
All right, sir. Thank you.
This as good as saying, I'm hungry. I come home and give me food now. My wife will say, wait, I have to cook something. No?
Yeah.
So similarly, trial also takes some time. But then if you want to cook and you don't have rice or wheat or bhaji at home, so you have to go to the market first, get it, and then talk of hunger. This is exactly what happens in a trial.
Right, sir. So we'll be taking up last question. This is from Sujin. They ask, to what extent should counterterrorism laws align with the international standards, and how can global cooperation be strengthened to address transnational threats while respecting sovereignty and diverse legal traditions?
Yeah, that is possible. You have international agencies who deal with all these issues. Now, take for example, this is another problem in the United States also. They have federal laws which are stringent, but then there is what is known as the what is it called? FISA courts. That every action that is proposed by a police officer of this kind of level is scrutinized by a judicial authority. I think it's a tribunal of 3 persons or 3 judges or 2 judges. The only problem there is Actually, it's not a problem according to me. Now look at what happens. Now whether A should be charged with terrorist activity or not is the discretion of some police officer. You say it is of the superintendent, SP level, so what? Even of the police commissioner level, so what? He can be wrong. So there should be some kind of a scrutiny saying, hey, what is the evidence on which you are saying you should be charged under the, not under the regular Bharatiya Nyaya Samhita? Hey, it will take some time for me to remember that name. Bharatiya Nyaya Samhita or under the UAP. Why have you charged him? Now, is there anybody who is asking questions? The questions will be asked only by the trial court. But the trial court will sit back and say, okay, we are charging with this. Okay, now bail denied. I'll hold the trial 10 years later. At that time, he will of course go into it. But this is unfair. Therefore, there should be some kind of a pre-procedure where you are required to examine, somebody examine and impartially examine. A judicial authority can look at, this happens in France. There are directors of prosecution in England. There are directors of prosecution in US. All this has been done. You can do it here also. I can't that you can't do it.
Right. Sir, thank you so much. With this, we come to the end of session. I'm sorry I couldn't take a lot of other questions that are in there due to paucity of time. But sir, once again,
They have overstepped my limit. I thought, oh, see, sorry, I should have
it's
got
our
all the
pleasure,
limit.
sir.
You
It's
should have stopped me
absolutely.
earlier only.
No, it's absolutely a pleasure and delight, sir. So I couldn't take more questions because the time is very less, and what we can learn from you is infinite and invaluable to us. Thank you, sir. Thank you so much for joining in and for your valuable time, and I hope to learn from you soon again, sir. Thank you.
Thank you. God bless you all. May
Thank
you
you.
all have safe life without getting into terrorists and terrorist activities and terrorism laws. May God bless you all.
Thank you,
Thank
sir.
you, Mansi. No, sorry. Yes, Samiksha. Thank you, Akanksha, but not.
Thank you
Thank-
so much. Thank you so much for your
I see
presence.
the Mansi here, so I kept on saying Mansi. Who is Mansi?
That's all right, sir. With regards to learners, please stay put. I have something more in store for you and lots in store for you. So please hold on. Thank you, sir. Thank you, sir.
Now that Mansi is there, bye Mansi.
Thank you so much. Thank
Yeah.
you, sir.
Can I take leave of all of you?
Thank you. Yes, sir. Thank you,
All
sir.
the best. All the best. Bye.
Bye, sir. Bye-bye.
Also,
So,
just
I,
one second before Samiksha proceeds, the questions that are left, we'll try to address it. Don't worry, we'll not miss out on your questions. Okay, we'll take a note of it and we'll try to address it. But meanwhile, we have something more for you. So yes, over to you, Samiksha.
thank you, Akansha. So thank you for staying put, so many of you. This is really overwhelming. I hope you had a great session. I hope this was informative for you as it was for me. I was like an excited college student all over again, scribbling my notes on my notebook. But hold on, we have lots in store for you. I'm going to present to you, I'm going to share my screen to you in a bit. But before that, I want to talk to you a little bit about the bonus registration opportunity that we have from 12:30 till 3 p.m. today. We'll be taking up bonus registrations for our courses on criminal drafting and civil drafting. And I'm going to tell a bit about the bonus, and then I'm going to talk about the course structure so you get the gist of what we have for you. All right. So the first thing is that if you register for this course from 12:30 to 3 p.m., you will get a flat 20% discount on the code that I'll be shortly giving out to you on both the courses on civil drafting and criminal drafting. Apart from that, we also have bonuses up to worth 4,500. So apart from the 20% discounts that you will be getting on the course, you'll also get a free access to any one of our self-paced courses, which is worth 1,200 rupees. So the self-paced courses that we have are incorporating of a company, basics of mergers and acquisitions and a deal making process, basics of GST, and acing jurisprudence exam. Apart from this is not all. We also have a 20% flat scholarship, which is about 1,800 rupees, depending on the courses that you choose from. You get a flat 20% scholarship on our civil drafting course, contract drafting and negotiation course, and legal research and writing course. I'm sharing the code with you on the chat box. Just give me a second. On your screens also, it's visible to you. If you apply these codes right now, you will get a flat 20% discount on your civil drafting and criminal drafting course at Lawctopus. All right. So these bonuses are worth 4,500. It is a bonus registration once in a lifetime opportunity that you get during and through the course of this webinar. So I request you all to please not miss out on this opportunity and register for this course. To answer your question, Anand, yes, you can avail a certificate for the session. You have to click on the link I'll be sharing soon with you. And you have to pay a nominal fee of 100 rupees and you can avail the certificate for the session. All right. I'm going to share my screen with you in a bit. I hope you can all see my screen. Perfect. So, at Lawctopus Law School, we have online courses on drafting because our mission, our aim is to be able to inform and inspire careers. And we aim to teach you what you don't learn in law schools. So drafting a skill which is so intermediary, so important, so basic, yet so foundational to anybody who's practicing or is in a law firm or is in a think tank is something we do not learn at law school, which is why we have Lawctopus Law School, wherein we have a complete online structure for you to learn the basics, the nuances, the intricacies of the subjects of criminal drafting and civil drafting. Now, there is a lot of scattered and exhaustive information with regards to the subject, but there is no one-stop solution wherein you can find all the foundational knowledge to build your base from and to start from scratch. So we not only teach you theory, but we also teach you drafting. Now, drafting, as we all know, as we have all observed, is a craft and a skill that can only be perfected with some time and a lot of patience. And that is what we aim to teach at our extensive course, which spans for 2 months. Along with these courses, you will have supplementary masterclasses and webinars like this one. Now, what are the benefits of doing LLS's criminal drafting and civil drafting course? Now, I'll be talking at length about the criminal drafting course, and after which I'll be inviting Mansi, who will be discussing with you about the civil drafting course. Now, our criminal drafting course, as is evident, will help you become a better thinker and an even better drafter. We will teach you concepts that are not taught to you in law schools about the basics of drafting, something as simple as how is the cause title put? How is an affidavit drafted? So these are not the things you ordinarily learn in a school, and after your law school, you might be clueless, you might be hesitant to put that into practice. So this is where we come into picture. But our courses are designed in such a way and structure that we bridge the gap between the facts that you are a first year law student or you're a practitioner with some kind of experience who's trying to divulge, who's trying to expand their horizons. So our language, our basics, our modules and our video lectures are designed in such a way that it tries to conceptualize all the target audience that we have in our mind. Along with these courses, we also have practical life assignments for you to do, wherein you learn about the real life drafting and how the applications are drafted in actual courts. Apart from all of this, we also aim to introduce students to career possibilities and different trajectories in litigations and what are the options they can look for and look forth. We also have a tie-up with a firm wherein we'll be providing you an opportunity with an internship, provided you become a star performer or you perform really well in our course. Apart from all of this, we also have an opportunity for you to publish on Lawctopus's journal Academic, which has an ISSN number. Now, we all know as law students how important are publications and paper presentations and seminars for us. So once you get an ISSN number, it's something of so much value that you can put on your LinkedIn, on your CVs, that will add a great value addition to your career trajectory, and which is why we want to be able to benefit you into doing that. Apart from all of this, we also give out career advice, career counseling, and CV advice with our career counselor we have in place. We also have a lot of career related webinars apart from the subject and theoretical webinars like this one. Now the mode of learning for the both courses, the civil drafting course and the criminal drafting course, is going to be very similar in nature. So I'm going to take you a little bit into the depths of that before Mansi talks to you a little bit more about the civil drafting course. We have different modes of learning. We teach you via our reading resources, which are put in place already for you and which you can access at any point in time through your forum. Then we have self-assessments after some modules as well, wherein you can assess your progress, where you can learn about how much you've learned. We also have recorded video lectures in place, wherein you can learn in bits and pieces about the subjects. Apart from that, we also have a live discussion portal wherein you can put in your questions, you can put in your suggestions, you can share something with your peers, with your faculty, with the other learners as well, and you can all collectively collaborate and learn together. We also have compulsory assignments and feedback. So as I already discussed, we have practical assignments wherein you will be drafting real life practical applications, and you will be learning more about how the practice is done at the court. A personalized feedback session is also held, and a personalized feedback in depth is also given to each and every learner to ensure targeted and specific learning. Apart from all of this, we also have live lectures once every week, wherein we at length for 90 to 120 minutes talk in depth about the practicalities of the course. And all these live lectures are recorded, and the recordings are put into the portal to be accessed by the learners at any point of time they wish to watch it and see it. Now, as I've already mentioned, we have periodical and regular master classes by legal luminaries in the field, wherein we talk about the practical subjects that require regular discussion and regular interaction. Apart from this, again, as I said, we have career-related, practice-related webinars also. For example, we have webinars about how to look for case laws, how to file online complaints on different forums, how to file an online FIR. So we also have subject-specific webinars. Moving forth, we are completely online. We have live lectures and assignments. We have one class per week. We have text-based modules and reading resources, which are prepared thoroughly. They are vetted seasonally by seasoned practitioners. All of this will be recorded. Then we have the live lectures, which are also put into the recordings. Then, as I already discussed, we have an online-based forum for doubt resolution. Then we have compulsory assignments and multiple optional activities for you to do within the course of 2 months. Now, to start your journey for civil drafting and criminal drafting, before I tell a little bit more about that, I would like to invite Mansi to talk a little bit about civil drafting course.
Thank you so much, Samiksha. I will quickly share my screen. Samiksha, can you stop sharing your screen? All right, can you all see my screen? Is it visible? All right,
Yes.
a very good afternoon to all of you. And I hope you all had a really, a good learning experience with us. And Samiksha has already told you a bit about the structure of our courses. I am going to quickly navigate you through the civil drafting course. So, guys, being equipped with the knowledge of court proceedings, be it of civil or criminal nature, and also knowledge of drafting of documents, be it civil or criminal, it is the very foundation of a successful litigator's career. And that is precisely what we are offering to you through these two courses that we are talking about. Samiksha has told you about the criminal drafting course, right? And just like that, the civil drafting course is also a 2 month long online certificate course, which will delve into the nuances of civil litigation. It will offer comprehensive insights into drafting of several civil documents, including plains, written statements, interim application, affidavits, and a lot more. So the very first question that you should ask yourself is why should you embark on this journey of learning drafting? And the very first reason is that, of course, there is no shortcut to success. I totally believe it. But if you learn these skills, it will save you at least 2 valuable years of trial and error in your legal career. What takes others years to learn through practice, you will master in a mere 2 months. The course is designed for law students, legal professionals, litigators, academicians. So whether you're just starting your legal journey or you're just navigating through the complexities of your law school, this course will help you to understand the civil litigation and drafting. The course is designed in such a way that even if you have not read CPC so far in your college, right? So you will be able to understand the intricacies of civil drafting. And if you are a legal professional, right, if you have already completed law and if you've just started practicing, it will help you to level up your skills to learn those little things that probably would take you years to understand. This course will be your golden ticket. And if you're someone who is a seasoned professional, right, you've been doing well already. Anyway, you can level up your skills and learn the art of civil drafting. And if you're an academician, if you're an educator, you're a researcher who's aiming to enhance their practical knowledge of litigation, both these courses will offer you valuable insights. And for law students as well, you will have an edge over your peers. It will, if you learn the skill of drafting, be it civil or criminal, you will have an edge over your peers. You will have an opportunity to bag better internship opportunities. I'll quickly tell you what all we are going to discuss in what all we are you will be learning with us in the next 2 months of this course. So our curriculum, it covers intricacies of court machinery and various stages involved in civil litigation. All the learners will gain practical skills on learning how to draft essential legal documents such as legal notices, plains, written statements, interim application, evidence affidavit, um, and application under Section 65B of Indian Evidence Act. And additionally, the course also offers insight into three distinct type of applications and petitions. The faculty for this course is a seasoned professional. She is a seasoned litigator. She knows a lot about civil drafting, and we will be having weekly live sessions, which will be, like just Samiksha mentioned, will be 90 to 120 minutes long. And she loves to have interactive live sessions. So even if there is something which you any sort of doubt or query you have, you can get it clarified then and there with the faculty. You can engage in meaningful discussions and make the most out of this course. And yeah, so you have this opportunity till 3 p.m. today. I mean, do not let this opportunity slip away. Make the most of it. And the sessions are usually conducted on weekdays, and the timings are from 7 to 8:30 p.m. It is completely online. There will be two practical assignments. You will be given personalized feedback on your assignments, and if you have any other sort of doubts also, you can get in contact with the faculty and learn these skills. So yeah, I mean, of course we want to become better litigators. That's the ultimate aim, of course. So if you have any such dreams, so just you need to stop dreaming now and start taking some real action. You have this opportunity till 3 p.m. Make the most out of it. And yeah, thank you so much for your time and attention. Over to you, Samiksha.
Thank you so much, Mansi. Uh, I will also share with you my screen and talk a little bit about the structure of the criminal drafting course for you. Give me 1 second. All right, I hope you all can see my screen now. So this is our course on criminal drafting and proceedings. We will talk at length about the introduction to criminal procedure and drafting in India. We'll talk about the types of offenses, the stages of criminal trial. So we'll talk about the pre-trial stage, talk about the trial stage, and we'll talk about the post-trial stage. So we will start from the start. How is an FIR filed? Where can an FIR be filed? How does an FIR look like? How do you quash an FIR? We'll talk at length about all kinds of complaints, whether it be under the NI Act, that is the Negotiable Instruments Act. We'll talk about maintenance. We'll talk about private complaints, where we'll also talk about the Domestic Violence Act. We will talk at length about bails, anticipatory bails, regular bails, etc. Where can you file one? How can a bail be accepted or rejected? The grounds of the same. Post that, we'll be talking about charge, discharge, protest petition, etc. Then we move on to the trial stage, where we'll at length discuss about the procedure before the court and all the stages of trial. So right from what does a charge sheet look like, how do you read one, and what happens after charge sheet, how are the charges framed, how are the evidences brought forth in front of the court. And what happens after this trial process? How is an appeal made? How is a revision made? And how is a special leave petition drafted at the Supreme Court? Apart from all of these, we also have in store for you a lot of short Golden Hello modules wherein you can learn in depth yet in a very crisp manner about all these subjects. We'll talk about cyber complaints, parole, furlough, compounding, plea bargaining, etc. Apart from this, we also provide compendiums of important case laws, common terminologies under the criminal law, and use of sample drafts for all kinds of complaints and applications will be provided to you. So all of this in just 2 months of time we'll be learning. So as Mansi very rightly pointed out, what people mostly learn in years and years of practice is something we've tried to bring together in a year. And more importantly, to give you a taste of all these opportunities, we also are introducing from this course onwards, free first live session. So I'm going to be sharing the link of the same with you. You can attend the free live session for all these courses for free to understand how these courses look like. However, the bonus registration opportunity will not apply for the same if you register after the first live session of the course. The bonus registration opportunity will only and only lie if you register for these courses during today up to 3 p.m. So I'm sharing the live session link with you all. You can also check it out. All right. Apart from all of this, if you want to avail a certificate for this session with Justice B.N. Shri Krishna, I'm sending you a link and the certificate generation code. Just click on the link and just rightly enter the code and you shall be able to download your certificate successfully. Aspirant asks who will be taking the classes. So for criminal drafting course, I am the faculty. I'll be taking the classes, wherein the recorded lectures are also done with by the seasoned practitioners in the field. About the civil drafting course, Mansi will be sharing her input.
Right. For the civil drafting course, the faculty's name is Sonal Chadha. She is a practicing advocate in Delhi High Court, and she has an experience of 6+ years. She has her expertise in civil and commercial laws, and she is really good with whatever she does. And our feedback, our experience with her has been impeccable, and you will get to learn a lot. I'm sure you'll get to learn a lot from her. The
Uh,
new batch is starting from 15th of February, guys. So you do not have a lot of time left. So make the most of this opportunity. And I can see there are a few queries about the other courses. For that, Samiksha will be sharing a feedback come expression of interest form with
yes.
all of you in the chat box. You can, first of all, please let us know how was your experience with this webinar, right? And if you have, if you want to enroll in some other course, please let us know in that form. And yeah,
Uh,
Samiksha
I
has
have
already shared it in the chat.
yes, I have just shared the expression of interest form with all of you all in the chat box, wherein you can also mention your email IDs and phone numbers. And apart from this, you can also mention the course that you're interested to take with Lawctopus. And our career counselor will get in touch with you at the earliest. And there's somebody interested in mooting also. So for mooting, we have Mansi. She handles the mooting course at Lawctopus. So you can also put in your queries there and we will get in touch with you at the earliest. I request you all to please fill in the expression of interest form. We would love to hear from you about how your experience was with Justice B.N. Sri Krishna and this session. Apart from all of this, I would also like to share one more thing. If you register till 3 p.m., you get a flat 20% discount. If you still want to wait some more and test some more, test the waters and then move forward, you can attend the free live sessions that we have for the contract drafting, criminal drafting, and civil drafting course for all the courses that are beginning in February. The civil drafting course begins on 15th of February. The criminal drafting course begins on 10th of February. And in fact, our contract drafting course begins today. Today is the orientation session for the contract drafting course. So you can attend the first live session, which are scheduled. You can see the schedule on the link. Sarthak, the cost for this criminal drafting course is 6,800 rupees. And after applying the coupon code, you will get a flat 20% discount. But this coupon code is applicable only and only for today.
Also, just to add a little bit to this, okay, I want to really, put some significance on this bonus registration opportunity, learners, for all of you. This is not something that we offer, frequently. This only is happening because all of you have attended the webinar, okay? This bonus registration opportunity does not just give you a 20% discount on the course that you're registering for, but it also, along with that, gives you an opportunity to use 20% discount for other very important and popular courses of Lawctopus Law School. I just want to highlight this aspect to all of you before you take a decision, okay? Even if you want to know more about the course, of course, this open live session will help you. Talking to our career counselors will help you, but this opportunity might not come to you. So try to use this opportunity before 3 p.m. today. All right. I will just quickly show you this opportunity that I was talking about, that apart from the 20% off that you get in your criminal courts and civil courts, that is for sure there. But apart from that, there are three very popular courses that we have. There are two popular courses apart from civil drafting and criminal drafting that we have at Lawctopus Law School, where you get 20% off. One is the contract drafting and negotiation course, the most popular course for our institution, and the legal research and writing course. Okay, so these are the two things that you can gain a lot of benefit of. Apart from that, you can also get a completely free of cost, self-paced workshop, either on incorporating a company, or on basics of mergers and acquisition and deal making process, or on basics of GST, or on acing jurisprudence exam. Anything of your choice and your preference. Everything is an important aspect that can shape your career. So don't miss out on this opportunity, which is why we are, really insisting. You can definitely take a decision on the basis of know more and explore more after registering as well. Okay, so do take it. Right now also we are here. If you have any questions with respect to this course, or how to apply the coupon code, or how to any other information that you need, three of us are still here. You can register right now also and let us know, and we can definitely make all of these benefits available to you immediately. Okay, so yeah, I just wanted to highlight this importance of this opportunity to all of you.
Sujin is raising his hand. Yes, Sujin.
I don't think they can unmute
They
your.
can't speak.
They can't. Sujin, you
I
can
would
write
want
in your
to.
query on the chat box.
Yes,
I
ma'am.
I would want to add something here. So, guys, we have shared the link of the expression of interest form with all of you. So, whosoever fills the expression of interest form will also be eligible for one free reading resource of the criminal drafting course. Right? right? So Akanksha has already shared the link in the chat box with you. And about the certificate, we've also sent the certificate generation link along with the code. Please note that the certificates will be emailed to you within a week. It will not be instantly available for download. You will get it over email in a week.
We
So
will be
please
personally
use your
sending it
time
out.
wisely. Right.
No, Lena, the
So
fees that is mentioned, 6,800 is the fees for criminal drafting course. The fees that is there for both courses have the same fees, but it is separate. Okay, 6,800 does not include both the courses, and you will get 20% off on each course. Also, Priya, we have resolved the query for you. Okay, great. So thank you so much, Priya, for trusting us, and I really hope you have a great journey in your civil drafting course. Others also, you can try applying the code just like how Priya faced an issue and we instantly resolved for her. If there's any issue that you feel or that you face, we are here to resolve it for you. So you can try to do that. See, Karthik, we will share the link of the free access to self-paced course. If you purchase the either the civil drafting course or the criminal drafting course, it's a part of the bonus registration opportunity. You can't get it in isolation. Only if you purchase this, that too within the 3 p.m. slot, only then will you be able to get this free access. And trust me, if you've applied the coupon code perfectly and if you've taken 20% off already, we will give you the access of all of these courses and make sure you get 20% off on the other contract drafting as well as legal research as well. Okay.
Akshat asks, will we get any certificate for the free course? Absolutely, Akshat, because you will have successfully completed the course. You will also be receiving the certificate for that course as well.
okay, and I hope Samiksha, we have shared the WhatsApp group link with
Yes,
the
I will
chat.
share it once again. I've already shared
The
it once.
recording of this webinar will be available. You will get the recording on the WhatsApp group that the link Samiksha is sharing with all of you. Please join the WhatsApp group. The updates about the courses and the recording will be available to you. Also, the free reading resource. So,
And
all the links we
I
will
will
share
also
on.
be sharing the coupon codes once again post this session ends on the group so that you can use that code to avail the 20% discount. To answer Anand, Anand asks, is the criminal drafting course helpful for someone who hasn't joined law school yet but will join this year? Absolutely, Anand. Because I think our initial internships are at courts only before we move on to firms, etc. And as law students, we feel very, very lost when we go into the courts and we're not trusted with work or we don't know how the proceedings are happening and what is happening all around. So this will get you a kickstart. This will help you get a footing over all your other peers and all your other students. And you will absolutely learn the basics of criminal drafting. You will learn about why, how, and which way the criminal drafting and criminal law in India is structured.
Just a second, there's one more question. So, Dia, what you can do is if you want to start the course from March, we'll let you know when the next batch is in case if you're not fitting in Feb. But you can still avail this opportunity and write to us that you want to, you can give a reference of this webinar. Avail this opportunity. That is only provided you do it before 3 p.m. today. Okay, Dia. You can take the course before 3 p.m. today. Write to us, okay, at courses@lawctopus.com. You can give a reference of this webinar and we'll shift you to your appropriate batch. We'll try to do the best for you, okay? But only because you're a part of this webinar, you are an attendee, you're taking interest, and I understand your desire for learning, so we can make an exception for you. So yes, you can utilize this opportunity for your March, for your next batch as well. Okay?
I request you all
Okay.
to once again, please fill the EOI form so that we understand if or not you like the webinar, what more do you want to see from us, how can we be of best service to you, and what courses would you be interested in, and our career counselor will get in touch with you at the earliest. So those of you all who have not filled the EOI form as yet, please click on the link and fill the EOI form. As the name suggests, it is expression of interest. So we want to learn, we want to know more about what you are seeking from us. Sujin, as answered, you will not be receiving the certificate immediately, even if you have made the payment of 100 rupees right now. We'll be emailing you the certificates manually and you shall receive them within a week.
Also, we are here for 5 minutes. You can take your decision. We are still here for another 5 minutes. Take your decision, and if you need any help, we are here for your query redressal. And meanwhile, Samiksha, if you could just send all the links one more time on the
I'll
chat
just do
box.
that.
The EOI form, WhatsApp group, as well as the link of the courses and the coupon code.
Yes. I'm putting them all together and sending you a one message with all the links included in it.
And on priority, please join the WhatsApp group if you still haven't, because if you've missed out on anything here, we'll also be sharing the recording of this webinar on the WhatsApp group. So I'm sure you don't want to miss out on that. So if you've first of all joined the WhatsApp group. Yes, Dipti, you can write an email to us on courses@lawctopus.com and you can choose your mode of communication. Don't worry. Shalini, we're sharing all the links one more time.
Just give me a second, Shalini. I'm compiling everything together and I'm sending it to you.
Sarthak, if you're joining law school this year, I suggest that, of course, you can definitely take this course, but I suggest that for you, a better course will be the legal research and writing course, because it is just going to give you a little more information, beginner-centric information. Of course, drafting comes a little bit, once you start the law school and then if you take these courses, it will be much more beneficial for you. For you, the legal research and writing course is something that I definitely suggest. So I'm going to share the link of that course also. And Sarthak, you can write to me personally if you need any help or any other scholarship for this course as well. I'm sharing my email ID on the chat box. Sarthak, you can write to me and tell me that you were a part of this webinar and that you're interested in legal research and writing course, and I'll do the best for you. Okay. So I'm sharing my link here, and I'm also sharing the link of the legal research and writing course, which will be better for all those who have still not joined law school. First of all, a very huge appreciation to all of you that you're taking so much knowledge before you join law school. So if you've still not joined, I think LRW, the course that I'm sending you right now is the best for you.
Also, we have a course on mooting. So those who are law aspirants, mooting is something which you should learn as soon as you join law school. So that course would also be really beneficial for you.
With
Definitely.
regards any and all of our courses, if you have any kind of queries, any kind of questions, please feel free to write to us at courses@lawctopus.com. And we will be very happy to answer to you at the earliest. All right. What is the certificate generation code to be filled? I've already mentioned it. You just need to write this code, aspirant, and you can get your certificate within a week.
Okay, so the moot course and LRW course is only for people who have still not joined law schools. Okay, that's why I'm sending. Don't get confused with the links. It's only specifically for Sarthak and others who want to still explore. All right, so is there any other question, learners? Do you have any questions with respect to the course or the coupon code or any registration details that you need from us? We are here for another 2 minutes.
We have a very interesting question from Akshat actually. Akshat asks, can we get an online internship at LLS? Very interesting you asked that, Akshat. We are soon rolling out a program on summer internship training program, the details of which will be released by the end of this month. And we will be having a very extensive 1 month program on training you with regards the drafting courses, the practical aspects of law, wherein you will learn and we will also learn a lot from you. So keep your eye out and you will be able to register for the SITP course soon, which shall be held in the months of summers, somewhere around May to June. We'll be having the SITP, the Summer Internship Training Program.
Hope everyone's joined the WhatsApp group, guys. Just scroll up and just look at all the links, just in case if you need it. Okay.
I will do that once again. I'll just share the links once again in case somebody has missed out on that message.
All right. Okay, learners. So please don't forget that this opportunity is available only till 3 p.m. Okay. Thank you so much for trusting us. Thank you so much for being so patient and for being so curious about so many things. And with even especially the students who have still not joined law school, I'm really happy with the audience today. Okay. So we'll meet soon, and I hope to see some of you, with us in our batches. And trust me and trust us with our learning. We will definitely keep you updated and we'll keep you informed about the right things in the right manner. Okay. And I really hope that you have a great journey with us. Okay. Dipro, if you want to enroll in April, as I said, Dipro, I've given the same offer to others as well. You can definitely avail the opportunity today, Dipro, because as I said, this opportunity, even in general, we don't give. Okay. This is a very rare bonus registers at the rate lawctopus.com. The email ID, we'll put it in chat box. You write to us there and tell us specifically with reference to this webinar that you want to take the batch in April because you're not available right now, and we'll help you. Okay, don't worry. But yes, you can take the offer today. Okay.
I will be sharing all the links once again on the WhatsApp group as well. Should you have any kind of questions while you will not be able to ask them to me on the group, you can message me privately and I'll be very happy to resolve all your queries, help you with the process, and get you started with our journey at Lawctopus Law School.
Okay, so thank you so much, everybody, and we'll see you soon. Thank you, Samiksha. Thank you,
See
Mansi.
you. Thank you, Akansha. Thank you, Mansi.
Bye, everyone. Have a
Bye.
good day.
Bye, everyone.